So as AJ mentioned, today Joel and I will be talking to you about non-disclosure agreements. I'm no Harvard lawyer, so I will try to explain this in terms that we mere mortals can understand. So what is an NDA? In simple terms, I recently graduated from my teenage adolescence, so secrets don't make friends, but friends make secrets, and that is how I understand non-disclosure agreements. Okay, so formally, non-disclosure agreements are legal agreements that protect sensitive information that contribute to projects, ideas, or products of the company that you may want to keep that information out of hands of your competitors, because part of running a successful business, as we may know, is maintaining a competitive advantage in specific markets. And it's hard to do that when everyone knows your secrets. And then when outsiders sign an NDA, they're agreeing to keep your information to themselves and use it only in limited purposes. So you're able to make friends by sharing your secrets, expanding your inner circle, and making connections with people who can help your company grow. When do I need an NDA? NDAs are infamous for covering up sexual harassment claims, but there are actual useful scenarios in which you and your company may want to implement an NDA. So we'll go over a few of those. You're going to want an NDA when you're presenting an invention or business idea to a potential partner or distributor, when sharing financial information or marketing information with a potential buyer of your business, when showing a new product or technology to a prospective buyer or licensee, when receiving services from a company or individual who will have access to sensitive information, and when allowing employers to access confidential information to do their job. And so this isn't a comprehensive list. There might be other situations when you want an NDA, and then there will also be times when you don't need an NDA. So for example, most venture capital firms will not sign an NDA just because they're seeing dozens upon dozens of pitches every month, and you don't want to be buried in legal obligations for companies that you don't necessarily have an interest in when you're seeing that many pitches per year. And then there will also be times when you think, I trust this person, we have a really great partnership, I don't think we need an NDA. And on that, RevRoad's policy is it's better to have one and not need it than need it and not have it. And there are instances when there's accidental disclosure, so people that you trust might not even realize what they're saying and that they're breaking your NDA. And then there are also times with personnel replacement. So when someone you trust leaves a company and then all of a sudden there's a new person that you don't even know. So it's better to just have it just in case, because you never really know the circumstances that could change. And so now we're going to have Joel come up and talk about the more complex issues and the key components of an NDA.
Thank you, Brynne and AJ. So we'll try to make this brief. I know NDAs are maybe not the most exciting topic, but we'll try to make it quick and hopefully helpful. And take my mask off. So we're going to go through 5 components that you'll see in most NDAs. I'll also mention a few others that you will often see, and talk about some things that often get negotiated in an NDA. First is the identification of the parties, usually pretty straightforward. You just want to make sure you have the correct name of the parties that are going to be sharing confidential information or disclosing it, and also receiving it, so that it's clear who has the obligation, whose information is being protected. Usually straightforward, I say that, but it's not always the case. In a very prominent instance that we've all heard about with Donald Trump and Stormy Daniels, where they had a settlement agreement that included some non-disclosure features. Stormy Daniels, of course, went to court, wanted to say that the NDA, that the agreement was not enforceable because Donald Trump hadn't signed it, and that was a problem. Donald Trump, his lawyer's response, was that he was not even a party to the agreement. And you can see here, if you look at the third line, in the second line, by and between EC, LLC, and or David Dennison. It's not clear. If it's or, David Dennison may not be a party to the NDA. If it's and, then he is. Anyway, this kept lawyers busy for quite a long time, which is not a good outcome for your company. It wasn't a great outcome for anyone but the lawyers, really. Um, go lawyers, yes. Someone did benefit from this. But I would say that there are probably 3 lessons that we take from this instance. If you want to write these down, this might be the time to write it down. 1, don't have an affair with a porn star. 2, is anybody writing? I want to go slow. 2, don't have an affair with Donald Trump. And 3, make sure that your legal agreements are clearly worded and that there's no room for competing interpretations. Yes, Scott. I'm not trying to get political here, but.
With this is that, we often go to attorneys, as I'm sure Donald Trump did, had this language written. He's not an attorney. I'm not an attorney. I've had a supplier agreement, before drafted by attorneys that then, down the road proves insufficient. So we're mere mortals in here, not attorneys, relying on attorneys, but oftentimes this wording, because it wasn't specific, and we won't know whether it is or whether it isn't.
Well, that's a good point, Scott, but I would push back on that a little bit because there's, attorneys speak English just like regular people do, and you can read this paragraph, even without a college degree, certainly without a law degree, and know that, okay, who are the parties? It says EC, LLC, and or David Dennison. Is David Dennison a party? And that's not even addressing the question of who the heck is David Dennison, right? But your point is well taken, and I would suggest that especially with an NDA, which is usually a 2 or 3 page agreement, read it. Don't just depend on the lawyers. If you can't read it, and if it's not clear to you, then bring it up. It should be clear. Don't just rely on the lawyers, especially in this case where the lawyer who drafted this agreement ended up in prison and is still serving a prison sentence. So again, bad outcome for pretty much everybody. But does that answer your question, Scott?
I still maintain that I can read it, but if I read this, to me it means that it's both. That it's between EC, LLC, and or David Dennison, both. Now, if my attorney gives me this, as the CEO of a company, my ability to sit down and read line by line and page by page every, these long legal docs, number one, it's not in my, I don't love it. Number 2, I may get it wrong too. I mean, if my attorney got it wrong, how will I, say that doesn't work?
Yeah, not all attorneys are going to do a great job. This one did not do a great job. But again, I would say, especially with an NDA, it's 2 or 3 pages. If it's not clear to you, bring it up. Don't just assume that, the lawyers know everything and they know how this is supposed to work and they understand it. You should be able to understand it as well, especially for an early stage company who, you may not have a lot of extra money to pay in legal fees. Your NDAs should be accessible. You should be able to understand what your obligations are, how your confidential information is being protected. But I appreciate your question, Scott, and it is a really good point. But again, it's the English language. It should be clear. Is there another question? Okay. The next component, what is confidential information? There's always going to be a definition in the NDA of what confidential information is. Disclosing parties are always going to want that definition to be broad so that their information is protected to the greatest extent possible. Recipients are going to want to make it narrow, precise, so that their obligations to protect that information are narrow. So just read it, When you read that definition, does this cover everything that you need to protect as an entrepreneur? If you're the recipient, just read it. Is this too broad? Does it cover oral communications? That can be tricky. It can be hard to protect communications that are given confidential information that is conveyed to you orally. Does the definition require that documents that are confidential be marked confidential? Those are all things that get negotiated. In the instance of in the example of oral communication, usually the compromise there is that, okay, if there's some confidential information that is conveyed orally, the agreement may require the discloser to follow that conversation up with a document that describes what the confidential information was and confirms that it is in fact confidential and to be protected under the NDA. Again, both sides should want to avoid any ambiguities as to what the information is and what the obligations are. That leads us to the next component, the obligations of the recipient party. Brynne already mentioned this, that the main obligations are for the recipient to keep the information confidential. Don't share it outside the organization. And the other is not to use the confidential information for its own purposes. That might contradict and might not be in the best interest of the disclosing party. If you're the recipient, you need to think about which employees of mine need to have this confidential information and make sure that you communicate to them what your company's obligations are with respect to that information. Finally, there may be in the NDA a provision that requires the recipient to return the confidential information after the term of the NDA or even destroy it and certify that it's been destroyed. One issue that comes up a lot is, should the NDA be mutual or unilateral? And that's just a question of, is information going to be shared by both parties, confidential information, or is it just going to flow in one direction? If it's the latter, then you really don't need a mutual non-disclosure agreement. The next component of an NDA is going to be an exclusion from that definition of confidential information. You'll see this in almost every NDA, and that would usually covers things like information that's already known by the recipient before the relationship with the discloser, information that's already publicly known, information that the recipient develops independently, information that's disclosed to the recipient by a third party without violating its own confidentiality obligations to the discloser, and finally, information that's subject to a court order. That just prevents the recipient from being in the awkward position of having to choose between breaching an NDA or violating a court order to disclose some kind of document or information. And the last component, the term. A disclosure of confidential information might say, why should the term of my NDA ever end? Why should the recipient ever be able to share my information outside or use it for some other purpose? Which makes sense. You can understand that. And I'll note, though, that regardless of how long the NDA lasts, the NDA should include a note that the recipient of confidential information isn't obtaining any intellectual property rights, no kind of license to the confidential information that is communicated to them. The recipient, on the other hand, will say, I want my obligations to end at some point. It's not fair for me to have to continue to keep this information confidential and to take steps to make sure it's not disclosed inappropriately forever, especially where most confidential information becomes obsolete at some point. It may be very valuable now, but in 5 years, 10 years, it's worthless. And the term of an NDA usually depends on the industry, which determines at what point and how fast information becomes obsolete. Normal terms are 2 to 5 years, but you see lots of different numbers there. And just at the end here, don't overlook the effective date. There's a lot of focus on how long does the NDA last, how long do my obligations last. But the effective date, a lot of times, companies will start sharing information anticipating that they're going to sign an NDA. They know that they're going to have it in place, but they really want to get started on the project. They start sharing the confidential information. A week or 2 weeks later, they finally get around to signing the NDA. And if the effective date of the NDA is the date that it's signed, whatever information was shared before that date may not be protected, and the discloser might be really disappointed to find out that those documents or information are not protected ultimately. 3 other provisions that you'll see often, and you may want to insist on including them in your NDAs. If the party is going to have access to the other's employees, you may include an employee non-solicitation clause. You'll see that a lot. An injunction probably should be in most NDAs. An injunctive relief provision allows either party or the discloser to say, for example, stop the recipient from disclosing information in violation of the NDA or using it inappropriately before it happens or as it's happening. instead of having to wait for the damage to be done and collecting money later, money damages later, which may not be an adequate remedy because that information is out and it's the damage has been done. Finally, NDAs will often include a jurisdiction and a governing law provision, which just says where the case has to be brought and what law will govern it in the case of a dispute. So we hope that this has been helpful. As Brynne pointed out, early stage companies have to be able to protect their confidential information, their intellectual property, but they have to be able to use it as well. And sometimes using it means disclosing it. NDAs are a good tool for achieving both of those goals. So any other questions? Do my best to answer them. Yes, sir.
Yes. Number one, I think that this is great information. So thanks for sharing that.
Thank you.
And I think that's a good example of what you guys do here at RevRoad, is give information like this and provide tools to help entrepreneurs. The other thing that I have noticed, because I've been around a few different blocks over the years, is that especially for entrepreneurs and startups, it's not a bad idea to get an NDA from some of your employees because they're the ones that become your competitors.
Yeah, absolutely. And that's a really good point. A lot of cases out there where employees leave a company. I think Google even had one recently with its self-driving car. Their hotshot engineer, Lewandowski, left, and he had all this trade secret information, and the litigation ensued. But there was an NDA with him, and it ended up helping Google in the end. But yeah, it's a great point. Companies should have an NDA and probably other IP-related agreements with their employees. Thank you.
Yeah, I'll second that. Really good overview of NDAs. I learned some new things about this, and so many questions about the Stormy Daniels and President Trump NDA and a series of other NDAs, but I'll refrain.
Thank you.
More germane to RevRoad. So we send out NDAs when we're talking with other parties, or sometimes on behalf of one of our portfolio companies. And it seems like about half the time, the response when we say, okay, we'll send you an NDA and then we can send you some confidential information, half the time the other party will respond, well, let us send you our standard NDA. Any counsel there whether we should use our own or accept someone else's?
That's an interesting question. And a lot of times it depends on which party has more leverage, which party is bigger. Usually the bigger entity kind of has a little more leverage and they can force the other one to use their version as the starting point. But again, as Scott brought up, you can still read it. You can push back on stuff. If it doesn't make sense, you shouldn't sign it, I would say. And in most cases, a reasonable other party will be receptive to reasonable revisions. I don't know if that answers your question very well, Bart, but there are issues of leverage and who needs it more. And a lot of times early stage companies are in the position of having to kind of use the bigger entities NDA draft as a starting point. But that doesn't mean you don't review it and make sure that you're okay with it and that you can live with, for example, the definition of confidential information and the obligations that you might have as a result. Any other questions? Thank you, Bart.
Does RevRoad sign NDAs?
RevRoad does sign NDAs in some cases. We're like a VC, though, in the sense that we see a lot of pitches, so we don't sign NDAs.
Typically you don't, right?
Right, we don't.
Yeah.
If we have on very few occasions, but not in the context of a company applying and pitching to us.
Right. So how do you define who you should insist on getting an NDA from and who you back off and say, we're not, we don't need an NDA? Because it seems like a lot of the people that are in a position to actually exploit your idea and take advantage of it are the ones that don't sign NDAs.
Well, that hasn't been my experience, but that would be a real concern. And if they were in a position to do that, I would think twice.
Well, I would think that RevRoad is. I mean, they've got a good network. They've got resources available to them where they heard a good idea and thought, yeah, this is kind of cool. Let's run with this.
Yeah, I mean, I can see where you're coming from with that. That's not really what we're doing, though. We're not starting.
I'm not saying that's what you're doing, but I'm just saying that.
Yeah.
Yeah, I mean,
We invest in, yeah, that's a good point, Seth. We invest in the good ideas that come to us. We don't steal them. We don't run companies on our own.
I know. I'm not I'm not pointing this at you. I'm saying in general, how do we discern whether or not we should insist on an NDA or not?
Yeah, I mean, there are some circumstances where you might take a risk and do it without an NDA. But if another party that you're talking with is really insistent and they're in a position to take your idea and run with it, if they're insistent that they not sign an NDA, that might be a red flag, and it might be a reason to tread very, very cautiously in preparation. I don't know if that answers your question. It's going to be a calculation, though, and a business decision in the end.
So if you don't sign an NDA, and a person that you disclose information to seems to have taken your idea and utilized it to their advantage, what recourse do you have?
There may not be much recourse. You would want to consider the circumstances in which the disclosure happened, the disclosure of your idea, but that's what NDAs are really there to protect you against, is that situation. I might need to hear more details on what happened in order to really come up with a good answer to that, though. In the world of intellectual property law, if you have a trade secret, for example, trade secrets are only valid as long as you keep it secret. And once you start disclosing it without protections, the law no longer recognizes it as a trade secret. Right? Absolutely, and it's tricky, it's complicated, and it's very, very important. And it's important that you do it right, and that you consider all the ways that you have at your disposal to protect your IP. And NDAs are one tool in that toolbox. Any other questions? If not, thank you. Appreciate it.